So we should keep it a little brief.
Mike Rappaport. I was actually going to ask the question that Steve Calabresi asked. So let me just do a follow-up, it's maybe a small point. But if, according to this story, look, the 13th Amendment was passed, and the 13th Amendment would have justified the Civil Rights Act. We had to pass the 14th Amendment just because people didn't sort of understand properly the badges and incidents point. So then we passed the 14th Amendment. Wouldn't they have wanted to specify? I mean, they just passed this amendment. They saw how people misunderstood it. Why would they have created such a possibility of misunderstanding when they specified part of it, but they don't specify all of it, especially when the whole need for the amendment, or a significant part of the need for the amendment, was to specify?
It's a great question, Mike. When I said, so the more clauses you study, the more you see similar methodological issues in different contexts. So this is a version of a question that always pops up. Well, this is you're reading text. They meant text. Why didn't they say it more clearly? And that's true of every single damn thing in the Constitution. They could have said it more clearly. So it's a fair point, but really not a knockdown point remotely, because all these things could have been said even more clearly. And part of it does require then immersion in the historical sources to think whether they thought they were. I would ask two questions: whether they thought actually it was kind of clear to them, and I ask a second question: was even if it was clear to them, where does it say that in the text, or what's the reading of the text that would warrant their confidence? And so they said it's not about voting, and I used to say, like Doug Laycock, well, it doesn't say it's not about voting, it doesn't say civil rights. And then I came to see the way in which it really was in the text, because privileges and immunities of citizens in Article 4 isn't about voting, and it's civil rights, and I came to see the way in which they thought they had put it in the text, arguably.
Well, that's a good point, but when the clause is added to clarify, you might think that additional weight is required to read stuff in exactly the way that wasn't clear beforehand. Mm-hmm. But
these are not knockdown arguments, I think. I really don't. On either side. They're,
I agree with that.
Next question, Jane.
Yeah, I wanted to pick up on Professor Amar's point about historical seriousness, and a little bit even go back to Professor Fallon and a couple of other things earlier in the symposium, and to Justice Markman's question. The point's been made clearly and throughout the symposium that originalism is not going to be easy. It's going to require a lot of work to get it right, just as it will with many things. But I guess I was interested in brief reaction, and obviously this is a hugely large question, but brief reactions. We've had very, very little, if any, comparative discussion of originalism versus other means. We did a little bit on the precedent panel. But with the problems that exist with originalism, how does that very briefly compare with the problems that exist with other methods of interpretation that judges and courts and even legislatures could or should use?
I think Stephen was going to start off that.
A comment growing out of that, which is if one followed originalism, and this was directed in the form of a question to John, if one followed originalism and one were trying to interpret a text which said, "Be nice," how would you figure out what the command was? Would you not inherently have to, in interpreting the command "be nice," take some account of the consequences of particular actions as part of interpretation? And isn't there a less extreme form of that problem, to some extent, implicit in the command of the 14th Amendment? It's not quite as general and useless as "be nice," but it's pretty general in some respects.
Two things. One, specifically in response to Steve's question, one of the things that ended up on the cutting room floor when I was thinking about what to say here was discussing something that is closely related to that. And the consequences of various interpretations of any legal text or any text, sometimes consideration of the consequences is called for by the content. And so it's necessary to have, it's a prior stage to identify the means by which you formulate the character of the content. Once you've got that, sure, there are going to be a lot of situations like be nice. Well, yeah, that's the kind of thing that brings with it consequences. And so one of the things to understand specifically about the originalism debates with respect to the 14th Amendment is that a lot of them take place not at the quite early stage of identifying as a general matter the object of interpretation that people are seeking, but are actually fairly specific questions about the meaning of particular provisions and whether to what extent they should be understood in terms of some purpose, for example. If so, how to formulate the purpose. And those are all questions in which consequences are going to be important, but they are questions that depend very much on the content of particular provisions. The other thing I want to say about thinking comparatively is certainly there are a lot of major approaches to the Constitution that require just as much history, and some ways harder history, than the approaches that go under the name of originalism. For example, an approach that takes seriously the idea that the unwritten Constitution is fairly thick and doesn't consist simply of the statement, the Constitution is the law, well, that thickness is also going to have to be in time if you're going to take, as Akhil says, a serious approach to applying that concept. And that will require, especially understanding, say, of the last 50 years of American history, not the sort of thing that people who do inquiry into most of the Constitution routinely do, but in fact, it's hard to get away from history given that the American political system and the American constitutional system, small c, in Constitution, are embedded in history.
Two quick things. One in response to Gene. When you think about two ways of actually being legal, the way of precedent and the way of the document, I tend to like the document better just because I think it's actually been wiser than the judiciary. That may not be true for the next 50 years, but I think over the last 200, it turns out that the people actually were wiser. The people said free speech, courts didn't give us that. The people said equal, they said apply the Bill of Rights, and courts didn't do that. They did their own things for a very long time. So I think that the document is wiser. On be nice, it does say establish justice. And what's interesting, and there's a moral seriousness here, it's established justice, just so we're clear, for the Americans. It's America's Constitution. So to hell with the Mexicans and the Canadians. It's not for their benefit. And slaves are conceptualized at the founding as not part of the people. Blacks are, free blacks are, Dred Scott gets that wrong. But blacks are simply seen as aliens, as are Canadians and Mexicans, and it's not necessarily designed for the benefit of the others. One of the things we didn't quite talk about is how the 14th Amendment talks about not just citizens, but persons. And quintessentially, actually, aliens among us. Again, not quite Canadians in Canada, but a really interesting expansion of the moral compass of the Constitution. But ours is still not one that has equal concern and regard for the people of Iraq or Canada or Mexico or even Great Britain.
Or even the aliens among us, in that the distinction between the privileges and immunities of citizens and the protection of the laws is unmistakable in the 14th Amendment.
And that's your article in the Yale Law Journal in part.
Well, thank you for an excellent panel. Thank all our panelists.